Now, McKenzie Picave don't work in criminal court because you're required to have a license to practice in criminal court. So that's solicitors and barristers and the like. And so unfortunately, McKenzie Picave isn't in criminal court, which I'm not overly disappointed by. But for the purposes of this video, I want us to go there together into criminal court just for the next few minutes. What we're going to explore is possibly one of the most heinous crimes that can be explored within criminal court, and that is the crime of rape. In a criminal court, a rape trial will invariably, purely because of the nature of the crime, will invariably either be tried by a judge or indeed by a judge with a jury. What will happen is that the CPS, the Crown Prosecution Service, will prepare their case. Their case will be based on evidence, it'll be based on witness statements, it'll be based on CCTV, it'll be based on DNA, it'll be based on a huge science surrounding the victim and indeed surrounding the alleged perpetrator. The trial will take place and either the judge or indeed the jury will make a decision. So those 12 people or indeed that one highly educated, highly experienced person will make a decision about the outcome and about whether the alleged rapist is guilty or not. That process, that trial could take a couple of days, that trial could take a couple of weeks. But at the end of that trial, at the same time as that trial concludes, the alleged perpetrator, the person in the dock being accused of the crime, will know their outcome. And they will know in their heart of hearts that science and evidence and witness statements and DNA and everything else that has been used by the forensic team and the detection team is what has ultimately arrived at the conclusion and at the verdict. Now let's change that situation for a minute. Let's now move ourselves to the family court. Now, in the family court, there is also an allegation of rape. In the family court, a party in a set of family proceedings can allege domestic abuse, can allege domestic violence, and within the confines of that domestic violence, they can allege rape. Invariably, that allegation of rape, which one party has stated has happened, they have stated it, they have written it down in a statement, and that is it. That's the sum total of that particular investigation. Then what will happen is the judge, the magistrates who are overhearing those proceedings, will rule for a fact-finding, also referred to as a finding of fact hearing. A finding of fact hearing is effectively a trial. It's as close as the family court is going to get to a trial. The person who is alleged to have raped the other party is going to find themselves in the dock on the day of the finding of fact, and they are going to be cross-examined by a barrister or a solicitor or indeed the judge in order to get to the bottom of those allegations. They are going to be asked about the allegations, they're going to be asked about the incidents, they're going to be asked about the events around which this assertion of rape has been made. At this stage, let's just pause for a minute and let's just reflect back to the criminal case. In the criminal case, where rape was alleged and rape was asserted, there is evidence. There is DNA, there is witness statements, there is forensic science around. There's potentially CCTV footage. All of that is in place in order to secure a conviction, to secure a positive verdict against the alleged. We're now back in family court. In family court, there is no DNA, there is no forensic evidence, there is no science. There's invariably not witness statements. There's certainly very little CCTV, if any at all, because it's probably inadmissible if there was any. All you are being tried on in family court is the say-so of the person who alleged. Now, the finding of fact might run for a day, it might run for a week. We here at McKenzie Picave have been in finding of fact hearings that have run for multiple days. Invariably, the ones where the allegations are complex, such as rape, where the allegations are heinous, such as rape. At the end of that finding of fact, the process is that the judge who has listened, there's no jury, it's a judge, or indeed a bench of magistrates. But the individuals who have listened to what has been said and to how the alleged has answered the questions put to them about this allegation of rape, they must then consider whether they feel that the person who is alleged has committed that crime, whether the accusation, the allegation is true. What do they base that on? They base that on a term within family law that we call the balance of probability. Now, the balance of probability says it's not about guilt. It is about it is likely that something has happened. So, having listened to what the party who has accused you of rape has said, and then having listened to how you have answered questions put to you in a highly anxious, highly nervous, highly charged, adrenaline-fueled finding of fact hearing, where there is no other evidence aside from what you are going to say and what the other party has said, your guilt, or indeed innocence, is going to be drawn from that environment. So, let's draw those comparisons again. Criminal court, police investigation, Crown prosecution have gathered the file, forensic evidence, CCTV footage, witness statements. There's a whole bank, there's a whole file that is going to follow you into court and find a verdict, be that against you or with you. Family law, the person who accused you is the evidence. The person who accused you is the credible witness. The person who accused you is the only basis upon which that trial, that finding of fact trial, is going to be based. At the end of the trial, the finding of fact trial, at the end of the 1 day, 2 days, 3 days, however long it is that's run for, the judge, or indeed the bench of magistrates, will then retire in order to consider their findings. Now, if you remember the criminal court, if the jury retires at the end of the trial, they go away, they think about it maybe for a couple of days, maybe for a day. But they come back within a day and you get to find out what happened. A judge may take time to consider, but they come back within a day or within a couple of hours and you find out what's going to happen. We're now back in family court. In family court, it doesn't work that way. In family court, at the end of that finding of fact, the judge or the magistrate seek the opportunity to retire in order that they can consider their findings. That retiring, currently, purely because of how tight the diary is in the family court system, that retiring potentially will be 2 months, 3 months. Here at McKenzie Picave, we have currently, right now, and we're in late 2022 when we're filming this, we have 3 finding of fact hearings that we're currently waiting for the outcome of, currently waiting to find out what has been said, and 2 of them are already 2 months into that waiting process, and 1 of them is 6 weeks into the waiting process. While we're waiting, what's happening to the person who's been accused? They're waiting too. They have hanging over them the outcome, unknown at this stage, of the finding of fact. They have no idea if the family court, in 6 weeks' time when they eventually bring them back, 8 weeks' time, 12 weeks' time, when they eventually bring them back, they have no idea whether they're then going to be told, in this court, we have found that you are a rapist, that you are guilty, most likely guilty of this crime that has been alleged. The criminal court process is robust. The criminal court process is based on a depth of investigation to ensure that the verdicts are sound, to ensure that the verdicts will stand up to scrutiny. The family court process is not robust. The family court process is based upon one person making an allegation against another, and on the day or the days of a finding of fact, one person coming across as more credible than the other. Thanks for watching. Thanks very much for watching. If you want to learn more about Daniel Picave Counselling, watch that video. If you want to learn more about McKenzie Picave Family Law, watch that video. And remember to subscribe, because 68% of you haven't. See you next time.